What's up? What's up? What's up? It is June 4th, and this is a pop-up episode of Black Civics. I am your host, Friday Jones. I am Friday Jones on all social media, and you are in this pop-up broadcast, sponsored, of course, by the National Assembly of American Slavery Descendants. And today, because we're pop-up, we're going to get to it. I do apologize for being late. I had some internet connectivity issues. We got the connectivity worked out, and I am here. I do apologize for being late, but we're going to jump right into it. Tonight is a reading of the United States Court of Appeals, 11th Circuit, case number 2313138. That is the Fearless Fund case. And of course, we had Edward Bloom filing, the attorney who was the attorney on the Harvard law case, American Alliance for Equal Rights, as the plaintiff versus, and he got everybody. He got the Fearless Fund Management LLC, Fearless Fund 2 GP LLC, Fearless Fund 2 LP, and the Fearless Fund Foundation Incorporated, all listed as the defendants on this particular case. And we're going to get right to it. I'm not going to read a lot of the notes, but I want us to understand that this is a reparations case. These cases are intentionally being done across the country in order to set precedent. And then we have companies, honestly, that I do not understand, like JP Morgan Chase, that gutted their DEI. JP Morgan Chase literally was in the slave trade. JP Morgan Chase has a history of not lending or having racial bias in its lending to African Americans, particularly American freedmen, who are the descendants of those who were enslaved and emancipated by the 13th Amendment. And despite that, despite the fact that they actually can defend themselves in the Supreme Court with a case like this, we've got this guy running around town suing everybody and anybody just to set precedents, and we're going to get right to it. So, before Rosenbaum, Newsom, and Lux Circuit judges, Newsom Circuit Judge says, in this appeal, from the denial of a preliminary injunction, we are asked to decide whether the Fearless Strivers Grant Contest, an entrepreneurship funding competition open only to businesses owned by Black women, violates 42 U.S.C. Code 1981, which prohibits private parties from discriminating on the basis of race when making or enforcing contracts. We must also decide as a threshold matter whether the plaintiff, the American Alliance for Equal Rights, has standing to challenge the contest. After careful review and with the benefits of oral argument, we hold 1, that the Alliance has standing, and 2, that the preliminary injunctive relief is appropriate because Fearless's contest is substantially likely to violate Section 1981, is substantially unlikely to enjoy First Amendment protection, and inflicts irreparable injury. We therefore affirm the district court's determination that the Alliance has standing to sue, but otherwise reverse its decision and remand with instructions to enter a preliminary injunction. And so, just so we're clear, the defense went with First Amendment protection. That was their defense. So, item 1A. Fearless Fund describes itself as a venture capital fund that invests in women of color-led businesses. Its stated mission is to, quote, bridge the gap in venture capital funding for women of color. Founders building scalable, growth-aggressive companies, end quote. Pursuit of that mission, Fearless supplies grants to businesses under its quote-unquote foundation arm. Fearless makes those grants on the basis of a competitive application process. The Fearless Strivers Grant Contest offers 4 winners $20,000 apiece and digital tools to assist with business growth as well as mentorship. See Fearless Strivers Grant Contest official rules, quote, official rules at 12. Importantly, for our purposes, the contest is open by its terms only to, quote, Black females who are ... legal U.S. residents, end quote. Ideation at 3. More particularly, to qualify for competition, a business must be at least 51% Black woman owned, end quote. 2023 Fearless Strivers Grant Contest information at 2. To select contest winners, Fearless assembles a team of 3 judges who evaluate eligible entries based on the viability and strength of the business. Viability and strength of the business, how the business intends to use the grant, and potential for the business growth. Official rules at 10. The judge assigns scores for each category, and the entry with the highest composite score wins. The tiebreaker is the potential for business growth. If a tie persists, Fearless will bring in a tie-breaking judge to apply the same judgment criteria. Because Fearless's contest has been challenged here under 42 USC, that's U.S. Circuit 1981, which prohibits race discrimination in the making and enforcement of contracts, whether the contest constitutes a contract is central to this dispute. Originally, the contest rules expressly warned applicants in all caps that by entering this contest, you agree to these official rules, which are a contract. Official rules. The rules provided that the contest winner would receive $20,000 and other tangible benefits. The rules then went on to explain that in exchange, Fearless would obtain the right to discuss, quote, and otherwise disclose the ideas in the contestant's entry or, quote, otherwise use those ideas without any additional compensation, end quote, as well as the right to use the contestant's name, image, and likeness for public relations, advertising, promotional purposes, and in other media, and that the contestant would release and indemnify Fearless for various liabilities and agree to forego litigation in favor of arbitrating any and all disputes. Shortly after the alliance brought the suit, Fearless made changes to the contest rules. Most conspicuously, the rules were amended to eliminate the acknowledgement that it constituted a contract. The new rules vested the foundation with, quote, sole discretion to void and disqualify entries that undermine its philanthropic agenda, such as those that espouse, quote, any particular political agenda or message, end quote, or, quote, communicate messages inconsistent with the positive images, end quote, with which the foundation wishes to associate. See Fearless Strivers Grant Contest Amended Rules. Although the amended rules tweak the obligation and benefits exchanged by Fearless and winners, the contest's basic outline remained the same. An entrant still had the chance to win $20,000 and obtain benefits in exchange for its submission. It still had to give Fearless permission to use submission, and it still had to weigh various claims that it might have against Fearless. Fearless planned to run the contest 4 successive times. Each entry period lasted a month, at the end of which Fearless would select a winner and within several days present the award. The American Alliance for Equal Rights is a 501c3 membership organization that, according to its founder, is dedicated to, quote, ending racial classifications and racial preferences in America, end quote. In this case, the alliance represents several members identified in this lawsuit as owners A, B, and C, all of whom operate their own businesses and wish to participate in Fearless's contest, but are not Black women. The alliance sued Fearless the day after applicants opened for the 4th entry period, challenging the contest under 42 USC 1981. In particular, the alliance contended, 1, that Fearless's contest constitutes a contract for 1981 purposes because interests enter into a bargain for exchange with Fearless when they apply, and 2, the contest violates 1981 because by its terms, it categorically excludes non-Black applicants from eligibility because of their race. The Alliance sought a preliminary injunction to prevent Fearless from closing the application process. As relevant here, Fearless opposed Alliance's request on 3 grounds. First, Fearless asserted that Alliance lacked standing to sue because the individuals it purported to represent, owners A, B, and C, were proceeding pseudonymously and hadn't adequately alleged that each member suffered a concrete or particular injury. Second, Fearless argued that 1981 didn't apply both because the contestant isn't a contract, the contest isn't a contract, and because it constitutes a valid remedial program. Finally, Fearless argued that even if 1981 applied to the contestant, the First Amendment protects it. Fearless separately contended that the Alliance couldn't show it had suffered irreparable harm of the sort sufficient to justify injunctive relief. The district court refused to enter the requested injunction. It concluded that the Alliance had standing to sue, and on the merits, it agreed with the Alliance's contention that 1981 applied to Fearless's contest and that the contest didn't qualify for any remedial program exception. But the court thought that the First Amendment may bar the Alliance 1981 claim on the ground that the contest constitutes expressive conduct, and it therefore concluded that Alliance hadn't shown a substantial likelihood of success on its merits. The district court separately concluded that the Alliance hadn't demonstrated that it would suffer irreparable injury, seemingly or at least in part because the court thought that 1981 does not authorize injunctive relief. This is the Alliance's appeal. All right, let's get to the appeal. And here we're getting to the opinion of the court in point 2. I'm just checking to see if we got any comments. Don't see any comments, so I'm going to keep on going. We begin with Alliance's standing to sue. According to the Supreme Court, standing doctrine is rooted in Article 3 of the Constitution, which authorizes federal courts to hear and decide certain classes of cases and controversies. U.S. CONST Art 3, so that's the section of law, Section 2. An organization may vindicate the rights of its members by suing on their behalf. See Students for Fair Admission, Inc. versus President and Fellows of Harvard. Oh, he referenced his own case. Collection 600 U.S. 181, 199 to 200 in 2023. In order to demonstrate the requisite standing to do so, an organizational plaintiff like Alliance must show that A, its members would otherwise have standing to sue in their own right, and B, the interests it seeks to protect are germane to the organization's purpose, and neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. There's no question here that Alliance satisfies the second and third prerequisites. It seeks racial equality for its members and interests germane to its purpose. And neither the civil rights claim it asserts nor the preliminary injunction it seeks necessitates individual proof or requires the individual members' participation. The Alliance's standing thus turns entirely on whether its members would have standing to sue on their own. To determine whether any Alliance member has standing to sue on his or her own right, we ask, of course, whether she has 1, suffered an injury in fact that is both fairly traceable to Fearless's conduct, and 3, redressable by the requested injunction. See Lejan versus Defenders of Wildlife, 505 U.S. 555 560-61 1992. That's another court case reference. To qualify for injury in fact status, a plaintiff's injury must be a concrete and particularized, and B, contractual or imminent, not conjectural or hypothetical, at 560. There's no doubt that Alliance members' alleged injury, exclusion from the contest is traceable to Fearless conduct, denying entry to non-Black applicants, and would be redressed by the injunction they seek, requiring Fearless to open the competition to non-Black entrants. The second and third prongs, therefore, are satisfied. The standing question here turns to whether the alliance adequately demonstrated that its members suffered the requisite injury in fact. Generally, when plaintiffs request prospective relief, we evaluate whether she has sufficiently demonstrated an intent to take the action and she asserts is prohibited. See Gratz versus Bollinger, 539 U.S. 244, 260-61 in 2003. If the plaintiff can show that she is able and ready to do so, she has demonstrated a concrete injury. Northeastern Florida Chapter Association's General Contractors of America versus Jacksonville, 508 U.S. 656 666 1993, holding in the context of an equal protection challenge that to establish standing, a party need only demonstrate that it is able and ready to bid on contracts and that discriminatory policy prevents it from doing so on an equal basis. To be clear, though, the plaintiff must do more than baldly assert that she is able and ready. She must also come forward with some supporting facts indicating likelihood that she will actually take the prescribed action. See Aaron Private Clinic Management, LLC versus Berry, 912. All right, we got 41 people in the house. What's up, y'all? What's up? What's up? Welcome to another episode of Black Civics. We're going through this Fearless case because this is ultimately about reparations. This guy, Edward Bloom, the attorney going all across America, suing, blue chip companies, threatening to sue them for DIE programs and everything else. This is the same person. DEI and everything and else, diversity, equity, and inclusion. Okay, so we are on page 9 of this opinion. So picking up where we left off on page 9, section B, Fearless challenges the alliance's standing on 2 grounds, both of which the district court rejected. First, Fearless contends that the alliance can't establish standing because it was identified as members only by pseudonyms. Second, Fearless argues that the alliance hasn't demonstrated that the members are able and ready to enter the contest should Fearless open to non-Black applicants. We agree with the district court that alliance has standing to sue. In Summers versus Earth Island Institute, the Supreme Court observed that in order to establish standing, an organization suing on behalf of its members must make specific allegations establishing that at least one identified member had suffered or would suffer harm. Similarly, the Georgia Republican Party versus the SEC, we held that an organization lacked standing because it failed to identify any affected members. All right, so they're saying, show us someone who's affected. See Jacobson versus Florida Secretary of State, 974, Circuit 2020. Based on those statements, Fearless urges us to embrace a hard and fast constitutional requirement that an organizational plaintiff identify the members it represents by name. And the argument goes because the alliance has identified its members only as pseudonyms owner A, B, and C, it lacks standing. And I'm going to drop this, you guys, if you can grab it. I want to share in case people want to know and want to come back for future reference. I just want, if you guys can grab this from the chat and share it across platforms, people can come back to this document should they need to at a future time. Okay, and so we are on page 10 now. Fearless has overread Summers and Georgia Republican Party. Neither decision supported to impose a naming requirement simply by using the term identify. Indeed, neither case had anything to do with anonymity or pseudonymity. In Summers, the Supreme Court held that an organization couldn't demonstrate standing simply by showing a statistical probability that some of its members would incur concrete injury without pointing to members or members who had in fact suffered such an injury. The court clarified, though, that an organization need only make specific allegations based on specific facts, that one or more of its members would be directly affected. Likewise, in Georgia Republican Party, we held that the party lacked standing because it hadn't pointed to any particular member who had or will have suffered harm. As a result of the challenge rule, neither decision, it should be clear, imposed a requirement that an organizational plaintiff identify affected members by their legal name. So basically, they're saying, organization, you just got to show us you got people that were affected. You don't have to tell us who they are, but you can sue on their behalf. So I assume that Attorney Bloom made an organization, found some people, and called them members just for the purposes of filing this lawsuit. I'm not going to be able to do it on this live, but if you don't follow at NAASD.org on social media, follow us, because I will go pull the paperwork to see when that particular alliance was actually formed and when its membership was formed. I'm curious to know that little bit of information. So I'm going to keep reading. In fact, the available precedent is to the contrary. Most notably in Doe versus Stencer, we specifically declined to require an organizational plaintiff to identify by name the members on whose behalf it was suing. And more generally, we have routinely permitted organizations to sue on behalf of pseudonymously identified members. And then they're referencing this case, Speech First versus Cartwright, 32 F 4th, 111-0-111-4, 11th Circuit in 2022. Okay, identifying an organizational plaintiff's member as Student A, Student B, and Student C. Unsurprisingly to us, in this case, addressing arguments materially identical to those here, at least two of our sister circuits have likewise held that pseudonymity poses no bar to a plaintiff. Okay, we get it. They're basically saying it doesn't matter if you identify the people as A, B, or C. As long as you have real people in your organization, you can sue on their behalf. So I'm not going to belabor that point. I'm going to hop to page 12 of the opinion. Fearless separately asserts that the alliance has failed to demonstrate that owners A, B, and C are able and ready to enter the contest. See Northeastern Florida 508 U.S. at 666. For support, Fearless principally relies on the Supreme Court's decision in Carney 592 U.S. at 53 and our decision in Aaron 912, a federal 3D at 1330. Both we think are readily distinguishable. The plaintiff in Carney brought a First Amendment challenge to a statute that effectively prohibited non-majority party members from serving as judges. The Supreme Court held that the plaintiff lacked standing because he had alleged only and vaguely that he would apply to be a judge, but has never demonstrated that he was able and ready to do so. He had identified no anticipated time frame in which he might apply, nor did he point to any prior judgeship applications. Nor, for that matter, did he know whether there would be any upcoming openings during the next cycle, and he made no effort to determine whether there would be. Similarly, the plaintiff in Aaron wanted to open a methadone clinic, but we held that its alleged injury was speculative because, although the complaint alleged that the plaintiff aspired to open a methadone clinic someday, it offered no facts suggesting that the someday was imminent or that the plaintiff had any concrete plan for a place to bring its clinic into operation. The allegations here are different. The complaint and the owner's accompanying declarations go well beyond boilerplate able and ready recitation. Together, they assert that each owner is prepared to enter the contest but is ineligible because she is not a Black woman. Describe the size of each owner's business, explain that each owner has met the contest non-race related prerequisites, specify how each owner would use the $20,000 if selected, owner A for improvements and expansion, owner B for website development and marketing, and owner C to grow her online presence in order to expand awareness. And 5, pinpoint when the owners would apply and, if permitted, to participate, namely in the 4th promotional period. So Fearless basically got through their first 3 promotional period, and then Edward Bloom was like, are there any female business owners? We're not going to talk about the fact that this same guy just beat affirmative action down and that white women are the #1 beneficiaries of affirmative action, but he went and found some non-Black, I don't know what ethnicity or race they are, but he found some non-Black applicants in order to form an organization, have them become members so that they could say they are ready and willing and able to file a lawsuit. Okay, before moving on, one word in response to our dissenting colleagues' repeated accusation that Alliance members here are flopping, i.e., disingenuously faking injuries for their own strategic advantage. See dissenting opinion at 1, 3, 6, and 21. Let us not forget we're talking about real live flesh and blood individuals who were excluded from the opportunity to compete in Fearless's contest solely on the account of the color of their skin. So this is also a women's only competition. So why he's not suing them for men to participate? Like, I believe race, gender are the things that the Constitution protects, but that's a whole other thing. Respectfully, victims of race discrimination, whether white, Black, or brown, are not floppers. C.F. Allen versus Wright, 486 U.S. 737 and 755. In sum, because the Alliance has sufficiently identified members who are in fact able and ready to enter Fearless's contest and has Article 3 standing to challenge the contest exclusion of non-Black applicants. On then to the merits. We consider 4 factors when determining the propriety of preliminary injunctive relief. 1, whether the plaintiff has a substantial likelihood of success on the merits of its own claim. 2, whether the plaintiff will suffer irreparable harm in the absence of relief. 3, the balance of the equities. And 4, public interest. See Gonzalez versus Governor of Georgia, 978 Fed 3D 1266 1271, 11th Circuit. They quote a lot of their own 11th Circuit. So obviously the 11th Circuit Court is a significant court. Likelihood of success on the merits is generally the most important of the 4 factors. Accordingly, we begin with the question whether Fearless's contest violated Section 1981, and if so, whether it fits within any exception of 1981's prohibition or whether the contest enjoys First Amendment protections. All right, first up, and we're at 29 minutes. All right, so before we move on, we're going to do just a quick commercial break. And again, this is Black Civics. We're doing a pop-up on this Fearless. We believe this case has reparations implications. And so we wanted to make sure that we read it and that people knew where to go to find it and not just read the headlines because it's important. So we're going to take a quick commercial break. And as soon as we get back, we're going to pick up where we left off on page 15.
Welcome. We are the National Assembly of American Slavery Descendants. Our mission is to advance the national movement for reparations. The United States Office of Management and Budget set 5 minimum standards for collecting racial data. The Black race is defined as a person having origin in any of the Black racial categories of Africa. NAASD has recommended that the OMB disaggregate data to accomplish 3 goals: decouple race from ethnicity, create an ethnic term that exclusively identifies descendants of persons enslaved in the United States, and create an ethnic term that preserves the American freedmen political status. The ethnogenesis of the African American identity is a result of ethnocide. The identity is from a people with shared history. Race identity plus ethnic identity equals peoplehood. Together, we can fix this dilemma with the OMB. We can build a coalition, grow the movement, and create a unified demand. What can you do to get involved? You can join NAASD today at www.naasd.org. You can email the OMB using our toolkit, or you can donate to NAASD so that we can continue this work. Thank you for your time, and stay connected with us on social media at NAASD.org. We are on Twitter, YouTube, Instagram, TikTok, Facebook, and LinkedIn. You can also sign up for our newsletter at www.naasd.org.
All right, we are back. You are back with Black Civics Collective, hosted by the National Assembly of American Slavery Descendants. And we want to just take a quick peek at who put the Fearless Fund together. We know some of these people. Let's go ahead and bring up the photos we have. And so I don't have everybody's name, but we know we grew up with Rudy, right? We grew up Keisha Knight Pulliam. She's being enterprising, her 2 business partners, working very diligently to get startup businesses. You know, people want to talk about, I think I saw Kamala Harris talking about there's a 50% increase in Black businesses by the SBA. But if your percentage of Black loans funded by the SBA is like 1%, I mean, it's not, 50% is not impressive if that's just getting us to 2%. You know, there are things we have to definitely be mindful of. But I'm going to share screen too, because I just want you guys to see the actual, I just want you to see like what I'm reading from. It's not where is it? Here we go. Yeah. This little document here. So you guys can just see, you can read along with me. This is the read along. So we're going to pick up here. We are on the top of page 15, continuing with the opinion. First up, does Section 1981 cover Fearless's context? In relevant part, Section 1981 provides that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, as is enjoyed by white citizens. The statute thereby prohibits intentional race discrimination in the making and enforcement of public and private contracts. Phillips versus Legacy Cabinets, 1320-21, 11th Circuit, quotation marks are exempted. So Arian Simone, Keisha Knight Pulliam, and Ayanna Parsons are the 3 owners of Fearless Fund. We want to recognize them all. Again, Arian Simone, Keisha Knight Pulliam, and Ayanna Parsons. All right. Fearless asserts as an initial matter that its contest is not a contract within the meaning of 1981's guarantee. The district court rejected Fearless's argument and concluded that the contest is indeed a contract. We agree. In seeking to avoid 1981's reach, Fearless faces an uphill battle. Recall for starters that Fearless's original contest rules warn applicants in no uncertain terms that by entering this contest, you agree to these official rules, which are a contract. Official rules at 3. Of course, as already explained, shortly after the alliance sued, shortly after the lawsuit, Fearless changed and amended the rules to drop contract designation and adjust the precise benefits and obligations exchanged by the parties. But the rose remained a rose. It is literally Hornbook law that a contract is an agreement to do or refrain from doing a particular thing upon sufficient consideration, supported by consideration, mutual consent, mutual obligation. The definition fits Fearless contest to a T. Under both original and amended rules, a winning entrant obtains $20,000 in valuable mentorship. In return, grants Fearless permission to use its idea, name, image, and likeness for promotional purposes and agree to indemnify Fearless to arbitrate any disputes that might arise. By any measure, that is bargain for exchange supported by good and sufficient consideration. In other words, it is a contract. On appeal, Fearless seeks to recast its contest as nothing more than a vehicle for conveying discretionary gifts that confer no enforceable rights or on contest entrants. We don't think so. As already explained, the contest ends in the formation of a contractual relationship between Fearless and the winner, and it's no answer to say that the contest itself merely facilitates the making of the eventual contract. The Supreme Court has made clear that 1981 protects would-be contractors here, the contestants, to the same extent that it protects contracting parties. Domino Pizza, Inc. versus McDonald's. The contest is exactly what Fearless originally acknowledged it as, a contract. Accordingly, by its express terms, Fearless next argues even if its contest is a contract within the meaning of Section 1981, it qualifies under a judge-made exception applicable to what Fearless calls valid remedial programs. The Supreme Court initially devised the remedial program exception to Title VII's anti-discrimination provision in United Steelworkers of America, AFL-CIO CLC versus Weber, 443 U.S. 193 in 1979, and it articulated a test to evaluate such programs several years later in Johnson versus Transportation Agency 480 in the U.S. 616 in 1987, a private race-conscious remedial program the court said is valid if it addresses manifest racial imbalance and 2, does not unnecessarily trammel the rights of others to create an absolute bar to the advancement of the employees, because Title VII and 1981 claims are often brought together in the employment context. We have since extended the remedial exception to employment discrimination cases arising under Section 1981, Farrell versus Parker Group, Inc. Okay, people, I am not an attorney. I'm not qualified to give law in any of these 50 United States. But this section right here, this section is why JP Morgan Chase needs to go head on and keep their DEI departments open and keep their Black funding special little program that they have going, because you know what? They have participated in racial imbalances as bankers. Wells Fargo called up on their practices. They actually have practiced racial imbalances. They could defend any program that they actually have. But those big companies let this guy punk them so that I don't know what they're paying their legal counsel for. What are you paying your legal counsel for if your legal counsel doesn't want to go up and defend itself in court when there are programs that are already backed up by data? This actually is kind of hard to see, but we're going to keep going. Without deciding the issue, we'll simply assume for purposes of this case that the remedial program exception applies to 1981 cases like this one that arise outside the employment context. So they're taking it out of employment context and putting it into the real world. Even so, Fearless's contest flunks the Johnson test because it unquestionably creates an absolute bar to the advancement of non-Black business owners. Johnson 480 U.S. at 626. By its terms, the contest is open only to Black females and thus categorically bars non-Black applicants. They want us to be minorities. They want us to open it up. We have consistently said things have to be specific to the descendants of persons enslaved in the United States, otherwise known as American freedmen. But we're going to keep going here. Fearless's lone response seemed to be that the contest doesn't absolutely bar non-Black entrants because they can seek funding from other sources. With respect, that's no response at all. It's tantamount to an argument so long as there are prospective funders out there who aren't discriminating on the basis of race, Fearless may continue to do so. Not only is that position anathema, my mom would be upset with me right now. I have to ask her how to pronounce that, but anathema to the principles that underlie all anathema, I've been corrected, to the principles that underlie all anti-discrimination provisions. It would, so far as we can tell, render Johnson absolute bar, caveat a nullity. Up to this point, we have agreed that the district court's assessment the alliance has standing to sue Fearless's contest constitutes a contract within the meaning of Section 1981, and the contest erects an absolute bar to non-Black applicants and thus fails to qualify for any remedial program except that might apply. The district court, though, ultimately concluded that Alliance wasn't substantially likely to succeed on the merits of its claim because the court said the First Amendment may protect Fearless's contest as a form of expressive conduct. For reasons we'll explain, we disagree with that conclusion. The First Amendment, of course, broadly prohibits the government from abridging a private party's freedom of speech. U.S. Constitution Amendment 1, and the Supreme Court has extended the First Amendment's reach to protect even so-called expressive conduct. See Texas versus Johnson 491, U.S. Circuit 397-406 from 1989. But, and it's a big but, when effectively controls our analysis here, the Supreme Court has clearly held that the First Amendment does not protect the very act of discriminating on the basis of race. All right? Like this case, Runyon versus McCrary, Circuit 427 U.S. 160 from 1976, involved a collision between Section 1981's prohibition on race discrimination in contracting and alleged First Amendment right. There, Black children alleged that private schools have violated Section 1981 by denying them admission on account of their race. As relevant here to schools defended on the grounds that First Amendment protected their rights to associate with those of their choosing. In rejecting the school's defense, the Supreme Court reaffirmed that First Amendment guarantees a right to engage in association for the advancement, beliefs, and ideas, but denied that it extended to the act of discrimination on the basis of race, quoting NAACP versus Alabama 357 U.S. 449 460. In particular, the court assumed that parents have a First Amendment right to send their children to educational institutions that promote the belief that racial segregation is desirable and that children have an equal right to attend institutions. But in words with particular resonance here, the court emphasized that it does not follow that the practice of excluding racial minorities from such institutions is also protected by the same principle. The court reiterated that the Constitution places no value on its discrimination, and that while indevious private discrimination may be characterized as a form of exercising freedom of association protected by First Amendment, it has never been accorded affirmative constitutional protections. Since deciding Runyon, the Supreme Court has continued to recognize and enforce the critical distinction between advocating race discrimination and practicing it. In RAV versus City of St. Paul, for instance, the court emphasized that where the government does not target conduct on the basis of its expressive content, acts are not shielded from regulation merely because they express a discriminatory idea or philosophy. Notably, the court cited as examples of lawful regulations such as acts, both Title VII prohibition against employment discrimination and Section 1981's prohibition on race discrimination in contracting. So too in Wisconsin versus Mitchell, the court cited Runyon as the example of a case in which it had previously upheld against constitutional challenge both federal and state anti-discriminatory laws and reiterated RAV's invocation of Title VII and Section 1981 as examples of permissible neutral regulation of conduct. They are showing us how to do this, people. So cite these cases, get the reference. Thank you for tuning in to this pop-up episode of I'm being told we're doing another commercial, but hold on one second. I just want to say the Black Civics Collective, we didn't rehearse this. We're seeing the headlines. We're seeing people make comments. And this is something in a reparations world we have to pay attention to. The legal court system in the United States is a third arm of government. And these people are playing checkers. They're playing the long game. They're not playing the short game here. They're playing the long game. You wanted to take a commercial break?
No, you're going to, and then I'm going to run commercial.
Okay. And so let me see. This thing is like 60 pages. And so I'm going to cheat a little bit and just jump ahead because there's no way I can get all 60 pages. There's no way I can get here. So basically they go in. Because of their arguments, they affirm the district court's determination and they basically reverse the prior court's decision. And that kind of buried Fearless. So I'm going to pick up here Rosenbaum, circuit judge who dissented. So let's just get a little bit of the dissent argument before we close out, because this is just a quick pop-up. We wanted to try and make sure you guys had the reference materials, you knew how to read it, not just read the headlines. No one doubts the sincerity of an Arsenal soccer player's desire to beat Tottenham, but he can't be allowed to try to win by flopping on the field, faking an injury near Tottenham's goal. For those who do not know, the object of flopping is to manufacture a foul that the player hasn't actually experienced to manipulate the referee into inappropriately exercising his power to award a penalty kick in the box when it's likely to result in a goal. Referees' vigilance prevents players who have a sincere desire to defeat their opponents, but who try to do so through manufactured fouls from commandeering referees to inappropriately exercise their adjudicatory authority to award unwarranted penalty kicks. I like where he going with this dissent, because that's more or less what I said, in that it wasn't the first round, it wasn't the second round, it wasn't even the third round. It was the fourth year that Fearless did this, that there was an organization formed and that we had woman A, B, and C who were ready, willing, and able to apply for this particular grant, even though there are grants everywhere, every day. But I digress. Article 3 standing requirement, which comes from the Constitution's limitation on the judiciary to hear only cases and controversies, prevents the legal version of flopping. Among other things, standing seeking to ensure that a party has a genuine and personal stake in the matter, a real alleged injury. The way the court's decision is not an impermissible advisory opinion, but instead addresses a real need to exercise the power of judicial review in order to protect the interests of the complaining party. Schlesinger versus Reservists to stop the war, 418 U.S. 208, 221 from 1974. As the Supreme Court explained, the powers of the federal judiciary will be adequate for the great burdens placed upon them only if they are employed prudently with recognition of the strengths as well as the hazards that go with our kind of representative government. Here, no one doubts the sincerity of American Alliance for Equal Rights' desire to challenge what it views as distinctions and preferences made on the basis of race and ethnicity. American Alliance seeks to do so by challenging the Fearless Foundation Strivers Grant Contest, designed to help Black women in the business world where they are grossly underrepresented as business owners. But as American Alliance has portrayed its members' alleged injuries, it has shown nothing more than flopping on the field. Although 3 of American Alliance members pay lip service to the idea that they are ready and able to participate in Fearless's contest, their declarations show a contest that none has genuine interest in actually entering the contest. Indeed, not one has established that she, in fact, able and ready to enter the contest and would do so in the upcoming period if the contest were open to non-Black women. So American Alliance's alleged injuries don't show a real controversy with real impact on real people among its membership. See TransUnion LLC versus Ramirez, 594 U.S. 413-424 from 2021. Rather, they reflect an attempt to manufacture an injury to allow American Alliance to challenge the contest. That is not enough for standing. So basically, this judge said there is no standing. The majority opinion does not hold American Alliance to the required able and ready showing. Instead, it incorrectly concludes that American Alliance has established that 3 of its members have a real and genuine stake in competing in Fearless contests. So it wrongly holds that we have jurisdiction. We don't. And because we don't have jurisdiction, we lack the power to consider the merits on Article 3 and must dismiss the matter. Section 1 of the dissent explains that governing law of standing when, as here, a party seeks to enjoin a program has never applied to participate in the program. Section 2 then recounts American Alliance's allegation as evidence and shows why it fails to establish standing under the governing law. So we are at 5 minutes out. I am going to just stop it there. Again, this is a pop-up show. I wanted to make sure you guys knew where to find the actual opinion. It's 60 pages long. There's no way we can get through it in an hour. I wanted to hop on to do a quick live, but because we lost time tonight with my internet, we're not able to do that. But if we can put on a pop-up spaces where we can continue the conversation. I would love if there are attorneys listening and or watching. I would love for some attorneys to join that spaces. We will set it up and put it. We will put it up. We will put it up. I also want to make sure that you guys know that we have a survey, our Black American Experience Survey. This really is for American freedmen families that have been here since 1776 and have gone through multi-generational harms in the United States. You can scan the barcode. We would love for you to take the survey, share the survey with friends and family. We are actually going to be taking the responses to help us to prioritize our advocacy in 2025. So that's going to be the plan to do our advocacy. And I'm going to stop sharing my screen. You want to put that back up? Did you have something else? Dana, I want to thank Dana who's producing tonight. I want to thank Nita on our communications team. Nita's in here, and I see her in the comments, holding down the comments. So I want to thank her for getting the comments in here and making sure folks see. You also can go to our website, naasd.org, and sign up for our newsletter. You can make donations. We definitely need donations. This is a time where descendant-led organizations are facing hostility in the funding world, and all of these things matter. We hope you appreciate the programming from tonight. Do we have any more commercials? Anything else to plug? I think we have it. Yeah, Father's Day is coming, so let us shout out the dads. Happy Father's Day. Yeah, I'll turn my camera off and you guys can just hear me. So happy Father's Day to all the dads. I also think we have something. Nita Rendon, one of our board members, actually has an event coming up for Juneteenth. And so I want to encourage folks to check her out if you can. It's a free concert, and we wanted to make sure we big her up. Also, we have the city of Los Angeles. I don't have anything to share on it, but we do have 2 Juneteenth events happening on June 19th as well. But you can go to LA Civil and Human Rights .lacity.gov and find out information on that. There's something at 10 o'clock and then there's something at 4:30 at USC. But there's going to be a lot going on, but reparations will also be going on the 19th. And so with that, we're going to shut it down. We will post when we're going to have the spaces, but this way you guys have the links. You can read it so we can discuss. But honestly, I feel like we are being given points of reference in how to beat them, right? They're using our laws and our legislation. They're quoting the NAACP. You know, they're playing the game. And I've consistently said this. It is in the law. That's the third arm of government that we cannot ignore. It's where we oftentimes lose. You know, we lose in the court system. We have the courts are stacked against us sometimes, not necessarily of our peers. If we had our own ethnic designation as American freedmen or as emancipated people, regardless of if you call us ADOS, FBA, African American, Black American, whatever labeling you want to put on it, if we had that identification with a government, a federal government, a department, a Freedmen Affairs Bureau, and we also had protections in place for us, we wouldn't have to have these kind of cases. There are things we need to do. I understand folks want to hop onto an international space with a plebiscite with the UN. I actually agree with that, but timing is everything. And there are some things we need to come together and do here. It's been great being on with you. I, again, apologize for the time. Peace and reparations. Until next time, I'm Friday Jones, and this is another episode of the Black Civics Collective, sponsored by the National Assembly of American Slavery Descendants. Thank you so much, and good night.